Slavery is the new normal. Just because it is normal does not mean it is all right. Just because it is normal for you to find internet posts about some ignorant man or woman injecting their own incompetence onto one concept or one document or another does not make that incompetence injected into the language of a document true at all. The falsehood of incompetence injected into certain language or certain documents that's perpetuated is a perfect circumstance where the blind follower follows the deaf and dumb follower who is following the crippled man. That's a long line of detriment, walking their way to a hill that leads to a rock bottom. A functional example of that analogy is the issue of lawful money and discharge. Ever so often you will see and hear valiant people confidently telling you that the only thing used for discharge is gold and silver. And somehow, for some reason, that HJR resolution affirms this. And that because the United States is under bankruptcy, that only gold and silver can be used to discharge. Confidently following this misnomer is a detriment to a lot of people. A lot of people to which res judicata reflects the same. House Joint Resolution 192 and Article 1, Section 10 of the United States Constitution does not grant you the right to discharge in any way, and this is why. It's verbiage that says that no state shall make anything but gold and silver coin to tender in payment of debt. Is referring to someone who is obligated to compensate someone or give someone back something that was owed. When the United States was created, when they went on their crusade to expand their empire, under the guise or mask of the quote founding fathers, the whole manifest destiny thing, when that was done, someone fronted them, aka the representatives of the United States and their trading companies. There were many different trading companies. Commerce was the medium used through that which was commonly already traded within the specific geographical location to which they were stepping into for the purpose of expanding their empire. In order for them to do that, war requires finance just as much as it requires information to be won. And finance involves something called modern money mechanics. See, this concept of modern money mechanics had existed way before that book called Modern Money Mechanics, issued somewhere in Chicago regarding to the trading companies and whatnot. Before you heard of modern money mechanics or that book called Modern Money Mechanics, the concept have existed since the Babylonian times. For lack of a better term, ain't shit modern about modern money mechanics. And because of that, when the representatives of the United States were waging war to expand their interests through commercial trading routes, whoever controls the commercial trading routes controls the money. Whoever has the money has the greatest influence. Whoever has the greatest influence and money has the ability to dominate people with brute force. But in order to get all that done, money is also needed to wage war. Therefore, the principles of modern money mechanic goes into play, where someone is fronted money for a certain act to be performed on the condition that it will simply be returned. When the representative of the United States engaged in these commercial interests, whereby they need monies to satisfy their intent, when the creditors fronted them some monies, the stipulation for the United States, not you, the one saying that you're not a United States citizen. Remember, most people who claim House Joint Resolution Article 1, Section 10 as a means of discharge are claiming that they're not United States citizens. Yet, this is applicable to United States and its citizens as a means to satisfy their debt by using gold and silver. That is their stipulation of satisfaction of debt, not yours. A lot of people are getting this twisted. And when bankruptcy is invoked, what happens with the different types of bankruptcy is it reorganizes the relationship that a debtor has So it's creditor. They use the term obligor, obligee. UCC 9-102 lets you know. Definition of an obligor means a person with respect to an obligation secured by a security interest. When this Article 1, Section 10 existed, there was a security interest. An obligor means a person, or aka a party, that with respect to an obligation secured by a security interest in or an agricultural lien on the collateral, owes payment or another performance of the obligation. An obligor is another term for a debtor. Obligee is another term for a creditor. When this thing called Article 1, Section 10, where it speaks that no state shall make anything but gold and silver a tender of payment of debt, they're letting you know the stipulation to how they, the United States, will satisfy their liabilities to their creditors is through gold and silver. So the more important question that everyone kind of looks over and ignores is, who are these creditors of the United States? When you begin to find out who the true creditor of the United States is, when these contracts that were entered into privately through lineages and whatnot, you'll realize the people who are the target of the expansion of empire, to which, if you're not clear about, the United States is part of the British Empire. If you're not clear about that, that's the reality of what's going on. The creditor who fronted monies to the representatives of the United States to wage war at North America and the rest of the world, you'll be shocked. They look very much like the victims of today's world. Looks mean nothing. Because whenever this United States Constitution was created, there were more parties beyond what people consider the founding fathers. There are those so-called Native Americans, or quote Moors, involved. Back then, those Moors, who played a huge role in molding and sculpting this Constitution, which even they admit that some of their ideas and principles come from the Iroquois Confederation, which we've shown in the past. When those Moors placed their hand in this, you have to realize that some of those Moors were in conflict with their own fellow brothers and sisters. At North America, some Moors wanted to do commerce and accepted openly the expansion of British Empire at North America, whereas some other Moors said no. That was the true civil war going on. All that you see in TV about some pale-faced people lining up as though it was pre-planned like a war game, all that is just reenactment. Whatever you see about some people carrying some flag and there's a group of people on the right and there's a group of people on the left, and then there are certain times they will go, all right, we're going to kill each other now. Now we're going to charge from left to right and then clash and kill each other. That is not how war takes place. Whatever painting you see about civil war is trash. That's not how it took place. That's not what was really going on. The faces behind the ones who were the creditors to the United States are also the faces behind the ones who assisted them sculpted it. Because those same people were conflicting amongst each other. Because they have different commercial interests. They look the same, but their interests and their minds were completely different. So they accepted foreigners to come in and get things done here. But nonetheless, let's not deviate too far. This stipulation of gold and silver has nothing to do with you, the one who say you're not a United States citizen. If you say you're not a United States citizen, do you not see that you're simultaneously contradicting yourself upon claiming Article 1, Section 10 as your ability or lack of ability to satisfy some debt because you don't carry gold and silver? Do you not see what's going on? And then House Joint Resolution speaks about something extremely important. So let's read it. Because House Joint Resolution says absolutely nothing about what people contend, or try to say that it's their core of the reason why they can discharge. House Joint Resolution is simply a reorganization that prevents them being the representatives of the United States, from being liable to meet the satisfaction of debt that they willingly entered into. Bankruptcy, in summary, is as simple as reorganization. Whenever someone's books are reorganized, it is balanced. Even for everyday man who does personal bankruptcy, that personal bankruptcy lets you know that, well, when you file that bankruptcy, your creditors get off your back under the condition that you can't do commerce in a certain way for a specific period of time. Business bankruptcy is far more effective, whereby your creditors are effectively subrogated. You're not liable anymore to satisfy whatever presumed debt that exists. And that was meant to benefit the representatives of the United States, not you, the one saying that you are not a representative of the United States, claiming a House Joint Resolution gave rise to some right for you to discharge. Stop lying to yourself. This is certified that the collection of the Library of Congress contains a publication entitled The Statute at Large of the United States of America, and that the attached photocopies from Part 1, Volume XLVIII, the title page and pages 112 and 113, on which appears House Joint HJRES 192, the Joint Resolution to assure uniform, listen to this intent, to assure uniform value to the coins and currency of the United States. They tell you what the intent of Congress is, which is to assure uniform value to the currency of the United States. Whenever something is being done in a uniform manner, this is another word for saying we're balancing the books. We were once debtors that are required to do something. Now we're making a uniform by balancing the books, because there's either a presumption that we've already satisfied it or a presumption that we cannot satisfy it because we're constantly in federal deficit, which another video on that is done. The video on how deficit work and the fact that it had been a deficit and House Joint Resolution and bankruptcy is actually not a bad thing on a business level. It's in this video called Discharge 101, Federal Deficit versus National Debt, House Joint Resolution 192 and bankruptcy. The video explaining the origin of the United States Constitution and Air Force Confederacy is in this video. Basic 101, Constitution 4 versus Constitution of. Go watch those for basic comprehension. So now this thing called House Joint Resolution 192 tells you that they want to balance the books in order to ensure uniform value of the coins and currency of the United States. Oh man, this covers so many more important things that many people are not talking about that affects them today, and that affects them as it relates to the United States dollar being digitized and the whole metaverse thing coming up. People are completely focused on the wrong thing. They are betting a dead horse that's insignificant, unapplicable, and unrelated to the subject matter of the exigent thing that is right in front of them. So let's read it. It tells you, whereas the holding of dealing in gold affects the public interest and are therefore subject to proper regulation and restriction. And whereas existing emergency has disclosed that provisions of obligations which purports to give rights to the obligee is the creditor, a right to require payment in gold or a particular kind of coin or currency of the United States. So when people try to throw all these fancy words, obligee, obligor, all they're speaking about is creditor and debtor. Someone who has the right to enforce a contract or someone who has the right to make a demand is called the obligee. The obligor is the debtor, aka someone who enters into a contract, who is basically a slave. So don't let all these fancy words confuse you when people throw all these fancy crap on the internet and social media. They themselves don't even know what the hell they're speaking of. They never done anything. They're paying taxes. They're working for another man. And they're here on the internet talking a bunch of crap about obligor or obligee. These are hypocrites. These are liars. Screwing you over. And you're following some concept that is inapplicable. And the people to which you're supposed to approach properly are looking at you like, oh, you don't get it just yet. Good. We'll keep engaging in tyranny. Why? Because you choose to keep lying to yourself. Because someone else have fed you that crap. And you're blindly following the deaf and dumb who is following the crippled man to jump over a hill. Don't do that. You're better than that. Whereas existing emergency has disclosed that provisions of obligation which purports to give the obligee, aka creditor, a right to require payment in gold or a particular kind of coin or currency of the United States. This requirement of gold and silver is this right here. And trust me, they're not speaking about you. The reason why in 1933 and all the other related actions like the Bretton Woods Agreement was done to remove gold from the public hands and give people a certain compensation, where when people speak about everyone giving their gold up when the quote government told them to do so, they're not telling you also that the people got a compensation for that. And then right after that, an inside trading was done whereby the value of those gold and silver were increased. And then A con was effectively done on the people, and the one who possessed that gold, aka the United States, now made the benefit from those gold and silver that they got, because the value has effectively increased and the people were effectively subjugated. The reason why those people, aka United States citizens, were being told to bring back the gold is because they anticipated giving those gold back to the creditor at that point. But they did that to trick their own employees, their own slaves, to con them and keep their wealth. And then on an international level, flip the game and say, well, we don't have it. And part of that included this right here called a HJR resolution. Keep all that in mind as you listen to this. Whereas the existing emergency has disclosed that provisions of obligation which purports to give the obligee, this obligee is not you that they're speaking of. They're speaking about someone else and power behind the closed doors that you will never see, that you will never hear, that assisted them constructed that constitution, who does not give a flying fucks about whether you call yourself a Moor or you say you're not a Moor, whatever you call yourself. They don't care about you. The level of game these people are playing, the people that the United States are indebted to, the level of game that they're at is so superb that whatever it is you think you know barely scratches the surface. They look like certain people who claim certain things, but they don't care about you just because you claim to be certain things. Where you yourself are not even competent enough beyond merely claiming to be one thing or the other. Again, whereas the existing emergency has disclosed that provision of obligations, which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency of the United States, or in an amount in money of the United States, measured thereby, obstructs the power of the Congress to regulate the value of the money of the United States. Meaning this principle within Article 1, Section 10 obstructs the power of the Congress in and of itself. Remember, Article 1, Section 10 is governing the legislative department. Article 1 governs legislature. Section 10 governs the power of said legislature as a fettered to each state. Because remember, each state used to have their own bonds and currency. And the Congress of the United States is a treaty to which each state were part of to come together to say, all right, maybe you guys shouldn't be issuing your own monies. Maybe we should be issuing United States currency, and all of you guys should unanimously accept this currency. Because we all have a similar enemy, which is our creditor. This thing goes so deep, people are clueless about half of 1% of the truth behind this Constitution, specifically Article 1, Section 10, and HJR resolution that they're going on about, thinking or presuming gives them right to do one thing or the other. And they're saying, well, this same Article 1, Section 10, whether they clearly say it or not, but directly say due to some emergency, the stipulation and requirement that certain kind of United States gold are required to satisfaction of debt obstructs the power of the Congress itself. Remember, the limitation was embedded into legislature and their power. Now they're circumventing it by bringing out a resolution that, well, that same stipulation without directly pointing to it. But for those who knows what's going on the inside, knows exactly what they're making reference to. Do you? Meaning they are circumventing this requirement, yet you're saying this is what gives you an ability to do something. And also you're saying you're not a United States citizen, yet this is applicable to United States, its enclaves, subsidiaries, and citizens. Do you see that what most people are going to as a remedy is a no-brainer, is a counterfeit, is counterproductive, is counterintuitive, is the opposite of what they contend to be doing? People don't get it. People are lying to themselves. And then they attempt to convince others that their lies ought to be accepted. They either do that with a lot of flair and short, unsubstantiated, groundless internet posts, or try to sue someone with it and then get shut down. And we'll show you that case law. Or in an amount and the monies of the United States measured thereby obstructs the power of the Congress to regulate the value of the money in the United States and are inconsistent with the declared policies of the Congress to maintain at all time equal power of every dollar coined or issued by the United States and the markets and the payment of debt. Now therefore be it, since there is an emergency, and that emergency disallows us to be able to regulate monies and do our job properly. Requirement of tender and payment of debt, which is gold and silver. It obstructs our ability to do our job properly. Now, therefore, be it. This is the truth of what this thing called House Joint Resolution says, that a lot of people don't want to accept. They are delusional with themselves. Now, therefore, be it. Resolved by the Senate and House of Representatives of the United States of America and Congress assembled that A, every provision contained in or made with respect to any obligation, every provision, it's making reference to the constitutional provision in Article 1, Section 10, regarding the tender or payment of debt being gold and silver, to their creditor, which is not you, that A, every provision contained in or made, this provision, once more, is making reference to Article 1, Section 10, whether you realize it or not. Every provision contained in or made with respect to any obligations which purports to give obligee, aka the creditor, a right to require payment in gold or a particular kind of coin or currency, or in an amount of money of the United States measured thereby, is declared to be against public policy. Public law and public policy are different things. This thing called the United States Constitution is under public law. There's a public law of Congress within the first Congress that passed this thing called the United States Constitution into law. These are the things people are not speaking of. So you're saying you're not a United States citizen, but you're trying to use something related to public policy. You're trying to do something completely unrelated to you. Are you trying to defraud someone else? It goes on to say, no such provision, aka Article 1, Section 10, shall be contained in or made within respect to any obligation thereafter incurred. This House Joint Resolution 192 is annulling their obligation within Article 1, Section 10. It is not reaffirming it at all. Yet, people trying to conjoin House Joint Resolution 192 with Article 1, Section 10, as though they are synonymous, when in truth, they are contradictory. The whole intent of House Joint Resolution 192 within the bankruptcy restructuring of who the creditor, aka obligee, and the debtor, aka obligor, being the United States, is to annul the provision and the requirement and stipulation of their creditor, because there was a change in power in the inside of what was going on back then, because the ones who were supposed to act as a guard to regulate this were still busy fighting against one another in 1933. They were fighting amongst one another before the enclaves of Great Britain, which is England and Scotland, before they came to North America. The Aboriginals here were fighting one another. And up till 1933, they were still doing it. So all this crap was going on. And keep in mind, all this 1933 era was part of the Reconstruction era, whereby the Aboriginals were kicked out of the government. These are essential, subtle things that you must know and not confuse yourself with information that is inapplicable. This House Joint Resolution 192 goes against constitutional provisions there in Article 1, Section 10. This is the truth of how this works. Every obligation hereafter, or hereafter incurred, then every debt the United States enters into. Meaning the presumption is we've declared bankruptcy, and these are the terms and conditions, the fact that we are subrogating and removing all the condition of debtor. And then to write a contractual issue moving forward from this point, 0.0, balance in the books, aka assuring uniform value to the coins. Coins being their own requirement of tender or payment. The uniformity of it being their balance in the books by declaring bankruptcy. When an entity declares bankruptcy, it is not a bad thing. That does not give you a right of action. It just means if you say that something benefits you, they in fact subrogated you, even though this does not apply to you. So there are many issues that people just don't get. Every obligation is heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment dollar for dollar. And any coins or currency which at the time of payment is legal tender. So now that brings the question, what is a legal tender? Which was meant to be used as a substitute for coins. which would effectively discharge any public or private debt that the United States have incurred. Any such provision contained in any law authorizing an obligation to be issued by or under authority of the United States is hereby repealed. But the repeal of any such provision shall not invalidate any other provision or authority contained in such law. This law is referring to the Constitution. All these people going on about tyranny, this, rights, this, why are they not speaking about the fact that this is the issue itself that's abrogating and overriding the Constitution? Yet, they're charging valiantly and saying, we're going to use this as a tool. The same thing that subrogated them and screwed them over is the same thing that they're trying to use, as though it serves the opposite of its significance. In other words, it shows incompetence. And then it tells you, in case you're not clear, as used in this resolution, the term, quote, obligation means an obligation including every obligation of and to United States, accepting currency. Are you a United States citizen? Most of these people who speak about House Joint Resolution 192 and their ability to discharge are claiming they're not United States citizens. And even if you are United States citizens, House Joint Resolution 192 does not work the way you say it does. But people will take it and use the lens of ignorance and gullible nature to misinterpret things just because someone who was incompetent told them something and they're just riding along with it. Now let's look at the case law of someone trying to use this, making it very clear that, look, buddy, your understanding of how this thing works is a little bit slanted. And even if it wasn't, it's still inapplicable to you. Listen to this. This case law also lets you know that certain banks are private entities. Sanford versus Robbins Federal Credit Union. Civil action case number 5:12-CV-306. Plaintiff filed a lawsuit August 1, 2012 and amended his complaint to add a general damage clause on September 7, 2012. He alleged that he presented the defendant with two, quote, electronic fund transfer instruments to set off and discharge debt associated with two bank accounts. The way most people who call themselves secured party creditors do this EFT transfer, electronic fund transfer instrument, is by using a closed account. Did you know that itself is fraud? And did you know that there are actually Title 18 charges that says that they can hold on to charges of bank fraud indefinitely and come after you whenever they want? Meaning if you're in your 30s or 20s doing all this EFT crap, or your 40s, they will wait till you're physically and mentally incapable, then it will come after you. You are putting yourself into a box by just following all this trash you see online to your detriment. But nonetheless, he alleges that he presented the defendant with two electronic fund transfer instruments to set off and discharge debt associated with two bank accounts. Just throwing buzzwords around without even knowing the functional aspect of it. He further alleges that the defendant accepted these instruments by operation of law, yet did not release titles to vehicles serving as security for the debt towards which the purported payment were made. What this quote operation of law is remains a mystery, but we'll see. As such, the plaintiff concludes the defendant is violating several sections of the Uniform Commercial Code. So this madam woman knows something called Uniform Commercial Code exists, yet failed to look at how instruments work, failed to look at the specific stipulation of private contract when it comes to instruments. The UCC has about 8 different ways, 8 different specific tools, to which according to satisfaction is just one of them, as to how you can get out of any debt. Yet this man or woman is doing some electronic fund transfer instrument and throwing around buzzwords and trying to use inapplicable things, which we'll read and see. As such, the plaintiff concludes the defendant is violating several sections of the Uniform Commercial Code, quote UCC, and committed fraud and theft by deception. The plaintiff also adds that the defendant is violating the secured property right pursuant to the 4th and 5th Amendment to the Federal Constitution. I guarantee you this man or woman did not have any secure property right to whatever that vehicle was in any way, shape, or form. In the response to the defendant's motion to dismiss, the plaintiff further states that underlying federal law regarding this action, such as House Joint Resolution 192, Public Law 73-10, Public Law Chapter 48, Stat 112, which we just read and shown, require federal jurisdiction. And now they're starting from the basic foundation of the requirement of original jurisdiction or supplemental jurisdiction. They are dissecting it from its core, little by little. Plaintiff should be allowed to argue federal law in federal court, okay? In other words, they're telling you this public law is a federal issue, and he has brought up no federal question. And the only situation where a federal question can be entertained, aka to be allowed to argue it, is if it's brought up. So if he's bringing up public law on a federal level, then it requires federal jurisdiction, right? The defendant argues, which is the bank that this man is suing, in its motion to dismiss, that the plaintiff's constitutional claims do not raise question of federal law sufficient to give this court jurisdiction. And even if they do, the defendant contends that plaintiff cannot state a claim for relief because the loans were never actually discharged. Now, on one hand, you might be thinking, well, the man is saying they didn't discharge it, therefore they're doing fraud. Why are they then saying that their affirmative defense is that it wasn't discharged? This is what they're saying in legalese, is that he has no right to discharge. For those without the eyes to see and the ears to hear, that's what this means. Because you would say, well, he is saying that they didn't discharge it, so they're fraud. Why then are they saying that it was never discharged? Oh, they admitted wrong. No, what they're telling you is since jurisdiction did not exist, he subsequently did not have the right to discharge in the first instance, because the law that he's bringing in is inapplicable to invoke federal jurisdiction. That is the reality of what's going on. That's the double speak going on. That's the legalese going on. That you have to see and hear. It's right on its face. But someone who has a premise of a state of mind of feud and, oh, they're bad guys, and even worse, pair that up with a flavor of incompetence, will read this completely differently. So listen carefully. And even if they do, the defendant contend the plaintiff cannot state a claim for relief because the loans were never actually discharged. According to the defendant, the two instruments at issue were drawn on a Magnolia State Bank account belonging to plaintiff, but Magnolia State Bank dishonored the instrument when they were presented because the account was closed. Where are people getting this issue that they can use closed accounts, which one, does not belong to them, and two, if it's under the status of being closed, for you, it's always going to be on the status of being closed. For them in the back end, it's always open. The issue of private contract puts you in a lower position whenever you open this bank account. And when you close it, you might still have the account number, router number, but that's theirs, especially when it's closed. Even if it's open, but especially when it's closed. Do you not know this is what bank fraud is? Most of these people are lucky these opposing parties are not bringing counterclaims against them for fraud itself. And then there are different types of fraud. There's intrinsic fraud, there's actual fraud, there's extrinsic fraud, there's material fraud, there's many types of fraud. Consequently, the defendant states it never actually received payment. So they're looking at the basic premise without even looking at the details. And the plaintiff's obligation remained in full. But whether or not the plaintiff made a valid payment, he has failed to state any federal claims upon which relief can be granted. Meaning he hasn't even invoked federal jurisdiction. This court therefore does not address the parties' underlying factual dispute. Now listen to this part. Additionally, the plaintiff's reference to House Joint Resolution 192, 73rd Congress, 1933, enacted by Public Law number 73-1048-112-13, 1933. The plaintiff reference to House Joint Resolution 192 is also insufficient to state a claim upon which relief can be granted. Listen to this. House Joint Resolution 192 titled, in other words, the intent of Congress, to ensure uniform value to the coins and currency of the United States. In other words, it's applicable to the United States, its enclave, subsidiaries, agencies, and contractors. Ask yourself, for you to invoke House Joint Resolution 192, are you part of the United States one way or the other? And two, the intent lets you know that they're simply balancing the books relating to the United States. Does that balancing of their books give you any right of action? House Joint Resolution 192, titled "To Assure Uniform Value to the Coins and Currency of the United States," states that an obligation requiring payments in gold or a particular kind of coin or currency, or in an amount in any money of the United States measured thereby, as we just read right here, are against public policy, literally, and that U.S. currency is legal tender for all debt. In other words, what House Joint Resolution just told you is that that note that you carry around is the discharge method. It is the discharge tool in place of gold and silver, as stipulated by Article 1, Section 10. And not that Article 1, Section 10 of the House Joint Resolution affirms the fact that gold and silver is the only means to discharge. The tool and the intent of House Joint Resolution is the opposite of how people intend to use it. Where and how people got this misconception, I've seen it in physical person, and I have seen it all over the internet. I have seen people call themselves different things, call themselves Moors, call themselves secure party creditor. They're not saying they're Moors, but they're saying they're secure party creditor. Some of them are saying one thing or the other. Whatever they're saying they all have a misconception of what this thing is. And while you're all shucking and jiving in misinformation, the tortfeasor is also shucking and jiving that, yes, good. They don't get it just yet. They're still dead. They're still asleep. Enactment of this resolution by Public Law 73-10 suspended the gold standard in the United States. In other words, it does not affirm that the gold standard is the means of discharge, but in fact suspended it. It circumvented it. If anything is to be done when it comes to pointing to this public law, the issue is the fact that it's unconstitutional, yet people are not speaking of it. People are hypocrites. People are confused. The plaintiff declares that the plaintiff being the guy who's saying that the bank is at fault because he used House Joint Resolution 192 and they didn't discharge it, so they're doing fraud. The plaintiff declares that presentment of the electronic fund transfer instrument, quote, discharged his debt upon receipt of the instrument, and that his payment was in full accord with the resolution and public law. Now he's intermixing the receipt of instrument upon discharge with accord and satisfaction with some crap about House Joint Resolution. When I say crap, I mean his misconception about how something works. Now he's just mixing, matching different flavors, wearing two different colored shoes with two different colored shoelaces, putting left foot and the right foot, going around confidently, yes, I'm doing something. Has a trash bag on saying, look, I have some specially made soup. And everyone is just looking at him like, what are you doing? That's what this man is doing on pen and paper. It's a disgrace. It's an embarrassment. No wonder these tortfeasors are comfortable screwing people over, because people have confidently done these things years after years after years. Remember, this case law is from 2012. November 20, 2012. You know how many more thousands of people have done this before this man? And then after this man? This is 2022 we're at. It is amazing that even in 2022, people are still doing this. It is mind-blowing how uninformed, unaware, and incompetent people are. He adds that, as a result of this law, quote, there exists an obligation of the federal government, Treasury, to discharge debt in exchange for giving them credit to create and control money system. Now he's going on some speculation he probably heard someone speak of. Are there ways to discharge properly? Yep, there are, but definitely not any of this trash this man or woman is going on about. The plaintiff later explained that the discharge part of the system was established because the bankruptcy of the United States of America in 1933. The discharge system has long existed in North America before 1933. These same people that throw around all the speculation that this man found and copied and pasted in some article someone wrote are the same people that will tell you, oh, the Uniform Commercial Code, it's an ancient merchant law. Yet they would also tell you, well, discharge came forth from 1933 and they now want to 32 UCC. People are confused, and thus they fail to do the mental toil and the mental labor to figure out the intricacies and subtleties and the details of why these things don't add up. They just ignore it and just throw stuff out there. They just throw a blanket of incompetence and hope something sticks. They lie to themselves and hope others accept that lie. And these people on the other hand, they educate you. As much as you hate them, they will tell you the truth. At this point, plaintiff also cites in passing U.S. Constitution Article 1, Section 10, lawful money, etc., etc. Article 1, Section 10 is the opposite of HJR Resolution 192. Yet this man is trying to use it as though it's uniform. You see the issue? At this point, the plaintiff also cites in passing U.S. Constitution Article 1, Section 10, lawful money, etc., etc., and subsequent codification, quote unquote. What the hell does this subsequent codification mean? Sounds like some fanciful phrase. Just copied and pasted. At least know what it means. Speak about the why and how, not some conjecture. Actually know what's going on involving whatever it is that you're saying. Because if he did, he wouldn't be mixing and matching things that don't go together. This mere listing of these potential source of law is not a statement of valid legal claim. Further, it is not clear how the plaintiff intends to apply the U.S. Constitution Article 1, Section 10. It is not clear how the plaintiff intends to apply U.S. Constitution Article 1, Section 10. Because Article 1, Section 10 of the United States Constitution contradicts the intent of HJR Resolution 192. That's why it's not clear how he intends to apply it. Does he know? But to whatever extent he lists it to imply that the system of lending money in the United States is unconstitutional, he is wrong. They're not saying that the system of lending is unconstitutional. They're saying the extent that he lists to imply that the system of lending money in the United States is unconstitutional is wrong. In other words, what he's saying as a foundation as to what's going on is wrong. Frankly, it is not clear to this court how the plaintiff finds support for his claims in the United States suspension of gold standard. His argument in this regard is vague and at times less than coherent, meaning he's just talking gibberish. And I know this sounds very harsh, but most people who go on about these things on these social media sites are clueless. They're just a bunch of angry people without substance, without comprehension of the language and intent of the things that they're saying, beyond what some follower who's following the follower says that they hear, and they're not just tagging along with because it's some instant gratification as a means to just follow the crowd. See, humans have a very great power called collective consciousness. This collective consciousness is what allows us to do amazing things once our minds are unified. But the same power of collective consciousness is our greatest demise. Because when one man or woman or one group of people carry wrong information that's detrimental to the totality of humans, and then those same humans carry it in mass, it would harm them. And nothing will stop them from accepting the fact that it's wrong until it's too late. Such is the issue that you're seeing right here. This man's mind, just as much as thousands of people who make the same contention this man is making, have been taken over by the collective consciousness faculty of the human reasoning, of the human mind and function, to their own detriment. Frankly, it is not clear to this court how the plaintiff finds support for his claim in the United States suspension of the gold standard. His argument in this regard is vague and at times less than coherent. To some extent, it appears the plaintiff's hopes to advance a watered-down version of claims other plaintiffs have unsuccessfully attempted via Public Law 73-10. Then other people have attempted to make the same speculation without even comprehending the foundation or its applicability. And then he's also doing the same thing. such as the vapor money theory, unlawful money theory, or redemption theory. How many people listening to this have read or are familiar or affiliated with people who know of some redemption manual or push the redemption manual? All that is just a bunch of speculation founded upon nothing functional. Deal with the reality of things. The quicker you begin to do that mental toil of accepting the fact, it's hard. It is difficult to accept the fact that you don't know shit. It is difficult. Therefore, you would rather die trying by grabbing onto something that you know will not benefit you, or you just don't want to accept the fact that you're wrong. See, you not accepting the fact that what you know or what you don't know is trash and it's detrimental to you is not, it's affecting you. And then you're contributing to the backward motion of humanity in total. Do you care about you or humanity? It's the question. Obviously you don't, because you're not wise enough to say, maybe something is wrong. Let me reevaluate this thing. Beyond instant gratification. Keep seeking instant gratification. See how far that takes you. Such claims are, quote, equal parts revisionist legal theory and conspiracy theory. And now they're just going to town and just labeling it however they want. You've allowed them to put you in a category that you should not. Who knows? Maybe you do fall under the category. And share a common thread in their use by plaintiffs seeking to avoid debt repayment. Now they're making you look like an irresponsible bum. How unfortunate. These theories appear to all somehow rely on various supposed consequences flowing from the 1933 suspension of gold standard. See this whole issue of suspension of gold standard and the misnomer involved as it relates to Article 1, Section 10 and the Fifth Amendment, and people submitting their gold and HJR resolution has been entertained in this video right here called Privacy 101 Digital Currency in Dollar, Executive Order 1406. And then it goes on to smash him to bits and pieces by putting him into a category of things limited to theory. It's embarrassing to even begin to read these details. Very, very embarrassing. It makes me cringe. But nonetheless, accordingly, the plaintiff's purported federal question claims are dismissed with prejudice. Prejudice means don't bring this trash back here anymore. Pursuant to the good old 12b6 break. Without these federal claims, the plaintiff's complaint invokes only state law in Georgia's version of UCC against a non-diverse defendant. Meaning the basics of jurisdiction is not even met in the first place. Reverse their citizenship. Supplemental jurisdiction. There's original jurisdiction. Do people know these basic things before even suing? Speaks about the difference of original and supplemental jurisdiction and how it's applicable. Speak about that on Patreon. So many basic things that people don't know. I mean, we speak about most of the subtle things, but this is the obvious stuff. It's not even subtle. Yet the obvious nature of what HJR Resolution 192 and Article 1, Section 10 says, people blatantly ignore it. Don't be one of those people who fall victim to the same faculty of collective consciousness that exists in you that's meant to be used as a tool for the forward motion of humanity, not the backward motion. Don't follow the follower who was blind, following the deaf and dumb who was following the crippled man to go fall off a hill. Don't make ignorance incompetence, which leads to slavery. Don't make it a norm. You are better than that. Be better, do better, and engage in that mental toil of questioning yourself whether what you know is right or wrong. Engage in that mental toil. Don't run away from it. That's how you evolve. That's how you create more brain cells. That's how the sympathetic and the parasympathetic get stronger, by you using your mind. Don't ignore it. That electrical impulse released by the axons in your nerves. Don't let them go dormant. Use it. Don't be a victim. Until next time, take care. Best of luck. Hey, beautiful people. I'm inviting you to come to my Patreon page. We speak about everything we don't speak of here on YouTube. On the Patreon page, we speak of establishing privacy in many different means, how to hold tortfeasors liable,
the different types of discharge, and the steps to actually do it. Now I'll be showing my own proof of the success. The intricacies involved in why and how it works, and the things no one else would tell you because they've never discharged themselves. The intricacies of settlements, suing people, and many other basic things like other tools that you can use privately, things of spiritual nature, because this goes beyond what you observe with your five senses. And if you just want to limit your remedies to just what you observe with your five senses, think again, because the other side is not playing in that realm. It's not an even playing field. Other things like study tools are shown things regarding trust and asset protection, and how to layer trust properly the way people seek it, and the advantage of how to do it, banking, the functionality of how they function, and the validity of it that a lot of people misuse or are misled by, where they think, oh, these other guys are bad, so now I have to just go into argument mode. No, you don't always have to argue. The law is perfected for your benefit if you're competent about it. Many things regarding child support, different examples of settlement checks, and the videos on it, the different aspect of how you can broaden your mind internationally beyond the little chicken scraps that people are picking up when it comes to passport and things of that nature, how banking work, how property protection work, the details of copyright, tort, privacy, different types of trust, the intricacies, and exactly why and how they are done, the intricacies that people from other parts of the world know about trust that you don't. Just because you read something on social media and whatnot doesn't mean you really got it. The intricacies of how to use certain jurisdiction and the stuff everyone speaks of. More in child support, more in trust, more in court, more in spiritual nature of things, etc., etc. The fact that tax avoidance is different from tax evasion. The importance of things in commerce and how to actually function in commerce. How to actually really do things as a natural person is beyond speculation. But let me give you this caveat. If you're looking for a cookie cutter or some quick fast food way, this is not it for you. Either here on YouTube or on Patreon. But if you're serious about your education and the function and application of it, rather than the mere accumulation of information, then come on over on Patreon. There are things we speak about over there that are universally and exponentially beneficial compared to that of the ones we speak of on YouTube. And more importantly, the practicality and the actual use of it. Take care. Best of luck.